Okay, so I'm going to give a brief introduction to the class materials for today, then introduce a few cases it's worth knowing about to prepare for discussion in class. Um, we attempted to limit many of the costs created by the low standard of originality by denying protection to ideas and protecting only the expression in a work, or even just the selection, coordination, and arrangement to the extent that those features constitute expression. Consider as we go how well this technique for limiting the scope of protection works compared to the possible alternatives, including granting no protection at all to low originality works or granting broad protection for the first comer regardless of the amount of originality. Here we see that Section 103 adds to the basic subject matter of copyright compilations and derivative works. An introductory point is that the copyright in a compilation or derivative work extends only to the material contributed by the author of the compilation or derivative work. If you've licensed the pre-existing material, of course, you could contract for exclusive rights, but that would be a matter for private agreement. If I write a new introduction to Leaves of Grass, I can't get copyright in Leaves of Grass itself, only in my contribution. In our discussions of originality, we have already considered works that incorporate pre-existing works. The Bridgman Art Library case is an example where the new editions weren't sufficient to constitute separate authorship, so there was no copyright in photographs of old paintings. In contrast, the Mezzotints and Alfred Bell involved enough addition of creative material that they were copyrightable in themselves, even though they were based on public domain works. US law long recognized protection for certain kinds of derivative works, but the 76 Act was the first to attempt a comprehensive definition. The definition of a derivative work does not indicate the extent to which a derivative work has to be distinguishable from the underlying work in order to justify a separate copyright. 103A suggests that at least the same standard of originality required by 102 applies. But what's not clear is whether that very low standard should be enough in the case of derivative works, or whether the bar should be higher. So I'm going to talk a little bit about the Batlin versus Snyder case. The court reminds us of what it says is the constitutional basis for an originality requirement, which is the requirement of authorship. One who has slavishly or mechanically copied from others may not claim to be an author. A bunch of reasons then are given for giving no protection to this bank. Consider whether these reasons are independently sufficient or they needed to combine. First, many of the claimed differences between the antique and Snyder's model are not perceptible to the casual observer. Special skill in reproduction does not suffice to give copyrightable material in the output of that skill in a plastic bank. You can see that principle echoed in Feist, in Bridgman versus Carrel, and in the Meshworks case. Some of the language suggests some doubts about the artistic merit of the copy. It took just a day and a half or 2 days work, and that wasn't good enough. But perhaps a better explanation of the divergence between this and some of the other cases is that the artist who adopts an unintentional variation to finish off her painting is exercising specifically creative skill and judgment, whereas the evidence didn't suggest that the decisions made during the reproduction process were creative decisions. And the short time frame is one piece of evidence supporting that characterization. Today, the claimant would plead and testify that of course those decisions were creative, and today's courts might well accept that testimony. The theoretical idea underneath all this is that there is a difference between copyrightable creativity and other kinds of creativity, including the creativity that lets you solve difficult problems of how to make an accurate copy, which are edging into the province of patent law. And there's a contrast in the case itself to a previous case finding copyright in a reproduction of Rodin's Hand of God. The reproduction in that case required extreme skill. The replica was itself original and creative, the Second Circuit says. This is, of course, in tension with what the court said about the exactness of the replica in the Hand of God case. In addition, the Second Circuit says, public access to a rare, highly creative sculpture supported allowing the reproduction to have copyright, to get copyrights incentives in play, but no such interest supported copyright in a knockoff of a not particularly valuable work like the bank. So this reasoning is in tension with the non-discrimination rule. And probably the best understanding of the Hand of God case is that it doesn't need to be distinguished, and because it is overruled by Feist, to the extent that it was the skill in exact reproduction that was rewarded by that case, the Hand of God case. So the rule that emerges, especially post-Feist, is when you're copying a copyrightable work, you need a substantial variation, not merely a trivial variation, in order to create something that has its own additional increment of copyrightability. We'll discuss this case further in class, but I want to introduce a later Seventh Circuit case that is also important in the evolution of the doctrine. And it's a case called Grayson versus Bradford Exchange. Briefly, there was an official contest to do paintings based on the Wizard of Oz. Dorothy Grayson won. Her resulting painting did not copy any existing scene from the film, but it was recognizably characters and settings from the movie. The movie's owners authorized use of a repainted version of Grayson's painting on commemorative plates, but they didn't get Grayson's permission, so she sued. The Seventh Circuit found that Grayson did not have a valid copyright in the image on the left. Posner's reasoning was that originality serves a legal function to prevent overlapping claims. You shouldn't be able to use your painting of the Mona Lisa to threaten suit against another painter who paints the Mona Lisa. So no copyright for her. There's not enough there that would allow people to understand what they could and couldn't do. You can contrast the rules about overlapping copyrights with patent law. In patent, you can patent an improvement on a patented process, even without the patentee's permission. The original patent holder can practice the patent, but cannot practice the improvement without the second comer's permission. In patent, these secondary improvements are known as blocking patents, and they often lead to cross-licensing. The idea is that the rule in patent law encourages the patent holder to bargain with improvers, avoiding holdout costs, and so you get more improvements. In copyright, by contrast, the copyright owner is perhaps simply less likely to want to practice most derivative works because what constitutes an improvement in creative works is so debatable. So we might not want to encourage their unauthorized creation and subsequent attempts to bargain, as we do in patent. So finally, I want to introduce a compilation case to give you a sense of how compilation analysis might differ. This is a case from the Second Circuit. Oh, I'm sorry, I forgot. I have my accused, I have the original plate in the painting, so you can take a look and see if you think that these are closer than the previous images were to each other, and if perhaps Bradford Exchange took something that Grayson really did add. And we can definitely return to this in class. And now I want to end on a compilation case, case involving Matthew Bender. Some background: in 1986, before Feist, the Eighth Circuit ruled that West's case reports manifested original elements of arrangement, and that Lexis's reproduction of West's star pagination copied elements of that arrangement. Matthew Bender similarly copied the text of the opinion, the caption, and the page numbers, but not the West headnotes, which were created by West, and puts it in an electronic database so you can search it. So the question is, when they copy the page numbers, have they copied a copyrightable part of the compilation created by West? The Second Circuit assumes without deciding that West's arrangement of cases is original. But a question perhaps for class, is the arrangement in fact original under Feist? They are chronologically ordered and then in circuit order by each day, both of which seem really uncreative. But there are some possible options for what happens when, for example, the Second Circuit issues 3 opinions in one day. The manifestations of West's arrangement are fourfold. There's the order of cases itself. There's the fact of then assigning them to volumes, where you end one set of cases and move to the next, roughly 800 or 1,000 pages, somewhere in that range, and that produces the volume number. Then there you have an initial pagination in the volume, and then you have star pagination, what you may know as the pin site. So one thing that this case highlights is that protecting selection, coordination, and arrangement is a different and perhaps more abstract endeavor than protecting something like angle and lighting selection in a photo. These are different kinds of choices. The Second Circuit says that a page number being a manifestation of a creative arrangement doesn't it make the page number itself creative and copyrightable. So it is the mechanical result of an overall system once the creative decisions has been put in place. The database that Matthew Bender made doesn't reproduce the arrangement. It's because all the cases are just in a big pile, data-wise. So there's no copying of what's copyrightable, which does not therefore include the volume and page numbers. Those are just mechanical offshoots of creative decisions. So that's Matthew Bender, and we will talk further about it in class. I will see you then.